So I've spent most of this week here at Saskatoon Court of Queen's Bench covering a trial involving a couple charged with the sexual assault of a 16-year-old girl. Now, the couple, who are both in their 40s, are accused of engaging in sex acts with the girl while she was allegedly intoxicated. There's really no denying that the girl was drinking that night. What's kind of up in the air is whether she was too drunk to consent. The Crown is arguing that she indeed was. At the time, the legal age of consent was 16 years old. This had happened more than 2 years ago, back in June of 2015. Now, the girl's recollection of events is that she was drinking with a group of adults in her basement, that she had just met the couple that night, and that she started blacking in and out. In one of the blackouts, she awoke on a couch in her basement and said that she was essentially being raped by the male partner in the couple while the female held her down. And this is a consistent story throughout all of her testimonies, whether it's in police interviews or at the preliminary hearing and the trial. However, there were some inconsistent statements that were made throughout the interviews as well. She added details to the alleged assault while she was on the stand, and the defense says that this proves that she is inconsistent and that she shouldn't be believed. The couple did take the stand in their own defense. They're not required to, but they said it was important to tell their side of the story. They said that they were at the house that night, that they did meet the girl, but that they really don't remember interacting with her much that night at all. They said that they briefly left the house and ended up walking back because they had forgotten a bottle of vodka. They said they went down into the basement together, looked for the bottle of vodka, couldn't find it, went back upstairs, and proceeded to have a bit of a domestic dispute over something that was completely unrelated to the girl. They said they both ended up leaving separately that morning, and that was all that happened. So it's two very different accounts. The couple saying that there was absolutely no sexual contact that night at all. The girl saying that she was raped. So the jury will have to decide which version of events they believe. The Crown's big argument is, why would somebody make this story up? The girl actually went to the hospital the next day and got a rape kit done, and a doctor's examination showed that she did have injuries to her genitals that were consistent with forceful penetration. The defense argues that while that is consistent with forceful penetration, it's not the only way that it can occur. The defense really focused also on the lack of physical evidence. No DNA was found on any of the blankets or pillows that were seized from the basement, and most notably, there was no DNA on the victim other than the victim's DNA. The jury has gone to deliberate, and we are awaiting a decision on this trial. I'm Bre McAdam at Saskatoon Court of Queen's Bench for the Star Phoenix.